Thanks, Jen, for having me here to present our research on misdemeanor prosecution. So this is a joint project with Jen Doliak from Texas A&M, who you know, and Anna Harvey from New York University. So recently, reform-minded DAs across the country have begun to not prosecute certain low-level nonviolent misdemeanors. From George Gascon in Los Angeles, Chesa Boudin in San Francisco, Rachel Rollins in Suffolk County, where Boston is located, Marilyn Mosby in Baltimore, and many more. These new wave of progressive prosecutors have been implementing all kinds of policies to reduce the prosecution of drug crimes, of quality of life crimes, prostitution, and other types of low-level, mostly nonviolent misdemeanors. Now, as you can imagine, they have also been facing backlash. Law enforcement, some members of the community, and some pundits have been wary of the potential safety implications of this increasing leniency in prosecuting crimes. Some have even begun to blame the recent uptick in violence and homicide, in particular, on these lenient prosecution policies for nonviolent crimes. And so it is within this context that we are asking the question, what is the impact of not prosecuting nonviolent misdemeanor offenses on subsequent criminal legal contact for the defendants who are the beneficiaries of this leniency? And in particular, for the purposes of today's talk, I will also talk and focus on what about the impact of not prosecuting nonviolent misdemeanors on future arrests and charges for violent crimes in particular. So why is this even a question, right? We might think that there are two potential consequences of not prosecuting an individual defendant, right? And so we think that prosecution itself could potentially have a deterrent effect, right? In the sense that if this individual defendant is prosecuted, goes through the process, goes through the criminal legal process, even if their charges are dismissed, they're getting an idea of the probability of being caught, of the consequences of being caught, and that this increased punishment could reduce the probability that they go on to commit future crimes or get involved in the criminal legal process in the future. We also know, however, that there are hundreds, if not thousands, of collateral consequences to even being charged with a crime, right? Charges, even that lead to a non-conviction or dismissal, can end up on criminal background checks that employers can see, that landlords can see, and this mark of a criminal record can follow people around for years. These marks may lead to fewer opportunities for these individuals in many spheres, and these fewer opportunities could actually lead to more future criminal behavior or more future criminal legal contact. And so we want to ask, what is the average impact of not prosecuting these defendants on their future criminal legal contact? In order to answer this question, we gathered data on nearly 68,000 nonviolent misdemeanor cases in Suffolk County, Massachusetts, where Boston is located. We have cases for nearly 20 years. And the data that we have on these cases includes information on the prosecutor who made the decision about whether to actually prosecute the case or not. And so once the defendant is arrested, an assistant district attorney in that office is going to make a decision about whether the prosecutor's office should move forward with prosecution, even if that case may eventually be dismissed or potentially convicted. We're going to be focusing on that very first decision about whether to move forward with prosecution on this case or not. And in Suffolk County, again, where we have our data, nearly 21% of the nonviolent misdemeanor cases that we focus on are not prosecuted. That is, the ADA assigned to make a decision on that case chose to not prosecute it immediately, basically declined to prosecute it. The case did not move forward. So one thing we can do is simply compare the average recidivism rates of defendants who are not prosecuted to defendants who are prosecuted to try to get an initial idea of what the potential consequences of non-prosecution are. When we do this, we see that on average, defendants whose cases are not prosecuted are less likely to recidivate. That is, there appear to be, on average, public safety benefits from declining to prosecute these nonviolent misdemeanor cases. However, the cases that are not prosecuted are quite different from the cases that are prosecuted. Prosecuted cases are more likely to have defendants that have recent criminal legal contact. Those cases have more counts and more serious counts involved in them, and those cases are less likely to be victimless crimes. And so simply comparing the average recidivism rates of the prosecuted and not prosecuted defendants is not necessarily going to answer the causal question of what is the impact of not prosecuting an individual defendant on their future recidivism. Those differences we saw in recidivism rates on the previous slide could be due to selection, could be due to the fact that the non-prosecuted cases are just different than the prosecuted ones. So how are we going to tackle this question? It happens to be that in Suffolk County, the prosecutor who makes the decision that initial decision about whether to charge your case or not is basically assigned to a defendant's case randomly. Now, it's not literally a bingo ball as I've depicted here in this graphic, but the policies of the office make it so that the individual ADA assigned to that case is completely independent of the characteristics of the case or the defendant. And so by chance, a defendant may get a prosecutor who is particularly lenient, one who happens to not prosecute on average, say 30, 40, or 50% of the nonviolent misdemeanor cases that that individual prosecutor faces. However, by chance, the defendant may also be assigned to a harsher ADA, one who doesn't prosecute, say, 5% or 10% of the cases, that the nonviolent misdemeanor cases that they see. And it is this randomness in who ends up with a more lenient or less lenient prosecutor that we are going to use to try to understand what is the causal impact of non-prosecution on future criminal legal contact, and in particular, future criminal legal contact for violent crimes. Now, in support of the idea that these cases are basically randomly assigned to different types of ADAs who make that initial prosecution decision, we can see that cases assigned to very lenient ADAs look identical on average to cases assigned to harsher ADAs. This makes us more confident that these policies are ending up in a basically random assignment of cases to different types of ADAs. And so what do we find? We find that for those cases, for those defendants for whom being assigned a more lenient ADA versus a harsher ADA could potentially change the outcome of the charging decision, those marginal cases, not prosecuting those marginal nonviolent misdemeanors significantly reduces the probability of a new arrest for that defendant within 2 years by nearly 58%, and reduces the number of new arrests for that defendant within 2 years by 69%. And these outcomes are particularly true for first-time defendants that we see in our sample. That is, that when the person is showing up for the first time, that leniency is really mattering in terms of reducing their future criminal legal contact. And again, this is a seminar or webinar that is focused on violent crime. And we can look at the reductions in future recidivism by crime type. And we see that for these marginal nonviolent misdemeanor cases that are not prosecuted, we are also significantly reducing the probability of subsequent violent arrests within 2 years by 64%. Large reductions even in future violent crime for those individual recipients or those individual beneficiaries of increased leniency on their nonviolent misdemeanor crimes. Now, one potential concern individuals might have is that a broader policy of non-prosecution, like we talked about on the earlier news articles for the various progressive prosecutor policies, could, while potentially reducing recidivism for the individual beneficiaries, for the individual defendants, could increase crime overall. And so we did take a look at this, and so far we see no evidence of large increases in reported crime after these broader non-prosecution policies go into effect. We looked at both Rachel Rollins' inauguration in Suffolk County, Massachusetts in early 2019, And we don't say she implemented a policy of non-prosecution for a list of about 15 nonviolent misdemeanor crimes. And we don't see any evidence of large increases in reported crime across several crime categories in Boston after she's inaugurated. And the implementation of other non-prosecution policies across the country, we similarly see no large increases in reported crime after those policies go into effect. And so overall, we see that scaling back prosecution for nonviolent misdemeanors could have large social benefits. We think there are many potential mechanisms for this. And in particular, at least in Massachusetts, not being charged with a crime significantly reduces the probability that a mark of that criminal record is going to follow this individual defendant around. But of course, it also reduces the time that the individual defendant spends tied up in the criminal legal system and avoids a record of conviction, as about 25% of prosecuted defendants in Suffolk County will end up with a conviction for that nonviolent misdemeanor crime. So these forces combine to reduce future recidivism, even for violent crimes, particularly for first-time defendants. Thank you very much.